Um, so um, I'm Eric France. For those of you who haven't met me, I am a commercial disputes partner in the London office of Mills and Reeve, normally based in the London office, but today I'm joining you from this room at the end of my garden in Theydon Boys, Essex. And today I'm going to be giving you a quick overview of what you should be doing to manage the kinds of contract disputes that we're expecting as a result of the pandemic. And what I really have in mind here are situations where one or other party is not performing the contract for some reason that's related to the pandemic. A lot of businesses are finding it difficult or even impossible to perform contracts in the way that they intended, and that may well give rise to quite a large number of contract disputes in the future. So I'm really going to be focusing today on the main ways in which it's possible under our legal system to escape liability for not being able to perform a contract. And I'm going to cover force majeure and frustration and how they might apply in the current situation. I'm also going to take a look at what other things there might be in the toolbox, what other options there might be apart from force majeure and frustration. And finally, I'm going to give some practical do's and don'ts for what you should consider doing at the moment in order to avoid storing up trouble for yourself in the future if you do end up in any litigation over any contract disputes. So, and as I said, we've set aside some time at the end for questions. You can put your questions by clicking on the Q&A button at the bottom of the screen at any time, and we'll go through those questions at the end. We'll also be sending you sorry, I should say, if you've also got any feedback on this webinar, then you can put that into the by clicking on the Q&A button as well and leaving your feedback there. And we're also going to be sending you an email after this webinar with some links so that you can access these slides, and also so that you can access a recording of this webinar. So there's no need for you to scribble down notes if you don't want to. Okay, so turning then to force majeure. Now this is there's a lot of interest in these kinds of clauses, these force majeure clauses, given that they may have been triggered as a result of the pandemic. Force majeure clauses allow parties to escape liability if the reason why they've not been able to perform the contract is down to some force majeure event as defined by the contract. So this is an example of a force majeure clause. I'm not going to read it out, but typically what you see is a bit of a shopping list of disaster events, and often accompanied by some kind of catch-all phrase. So the catch-all phrase here is in the second line there, that acts beyond the party's reasonable control, and this clause provides that if a force majeure event has happened and the clause is triggered, then neither party is liable for any delays or failures in performance of the contract. So now, whether or not you're concerned about your own ability to perform a contract or worried about another party not performing the contract, there's really 5 key things you should think about. First of all, you should review your key supply contracts and any other key contracts you have, and check whether or not those contracts contain force majeure clauses. Second point is that you need to check the scope of those clauses. So if the clause expressly mentions epidemics or pandemics, then the current situation will most likely be covered. If it doesn't mention epidemic or pandemic, then you really need to think about whether the clause contains a catch-all phrase and the scope of that catch-all phrase, and whether or not the pandemic will come within it. Third point there is you need to think about the causation requirements. So some clauses will require that in order for the clause to be triggered, the force majeure event has to have prevented the party from being able to perform the contract. Other clauses might impose a lower standard, like hindered or delayed, for example. And this is important because there could well be a dispute between the parties about whether or not the pandemic is the real reason that a party is not able to perform the contract or not. So one party might, for example, argue that, hang on, the real reason why you're not able to perform this contract has nothing to do with the pandemic. It's for example, because of your financial position, your weak financial position before the pandemic even started, or something like that. So it's important what language the clause uses to do with this causation requirement, because it could well be there could well be a dispute between the parties about it. So if the force majeure clause is triggered, though, then you need to consider what the consequences of that are, and different clauses will provide for different consequences. So you may have a force majeure clause which says that the parties' rights and obligations are suspended, or that one party shall not be liable during the period that the force majeure event is impacting on the ability of the party to perform. So that's a kind of suspension of obligations clause. Other clauses might actually provide for the termination of the contract altogether if a force majeure event has caused the party to not be able to perform the contract. And so if you have a suspension type clause, then what you need to appreciate is that once the impact of the pandemic subsides, then the parties' obligations under the contract will come back to life, and the parties will have to carry on performing the contract. If you have a termination type clause, then that will bring the contract to an end altogether. Often the termination type clauses have a requirement that one party has to serve a notice on the other, and often there'll be a time limit for serving that notice if they want to elect to terminate the contract. So you need to look out for if there's a requirement to serve a notice and what the time limit is. Finally, if there is no force majeure clause in the contract, then you need to consider what other means there might be for a party to escape liability under the contract. And the two main ways that a party might be able to avoid liability are the doctrine of frustration, and also if a party has some right to terminate the contract. So I'm going to cover both of those things next. So frustration. This is a bit different to force majeure. It doesn't depend on a clause in the contract. There's no clause to interpret. Frustration is a common law doctrine that has been invented by judges in cases that they've decided over time, and the judges basically frustration is about the idea that it's an exception to the normal rule that parties will be held to their promises in a contract, even if the parties have made a bad bargain. If one party's made a bad bargain, tough luck, you have to carry on performing the contract. Frustration is an exception to that, and the idea is if something happens that's so outside what the parties could have expected, might happen when they entered into the contract, then the court will interfere and say, well, despite the normal rule, we're going to say that this extraordinary thing has happened, and so you're relieved from your obligations to carry on performing the contract. So what counts as a frustrating event, and will it include this pandemic that we're all going through? Well, the courts apply some criteria as to what amounts to frustration. So I've set that up there on the slide. So the first thing is that there has to be the frustrating event has to happen after the contract was made. The second thing though is that the frustrating event has to be regarded in law as fundamental, and that means that it has to be something which strikes at the very root of the contract, and which is something which is entirely beyond the control of the parties when outside their contemplation when they entered into the contract. The next criteria is that it has to be something which is not due to the fault of either party, and finally, it's got to have whatever the event is. It's got to have an effect on the ability of the parties to perform the contract. That's truly sort of extraordinary. So it has to be something which renders further performance of the contract impossible or illegal or radically different from what the parties intended at the time they entered into the contract. So will the current pandemic amount to a frustrating event? I think the answer is it will sometimes, but it depends on what effect the pandemic is having on the performance of the contract. So just to illustrate that a little bit, there is one case in the world that we know of dealing with the effect of epidemics on contracts and whether or not that amounts to frustration. There's a Hong Kong case there, put the name of it on the slide, and in that case, it's all to do with the SARS epidemic that struck in Hong Kong in about 2003, and a tenant argued that the SARS epidemic amounted to a frustration of a tenancy agreement. And Health in Hong Kong issuing an isolation order, interfering with the ability of the tenant to enjoy the premises in the usual way. The isolation order was only for a 10-day period, and the lease was for a 2-year period. And so the court in that case said, well, all right, the SARS epidemic could be a frustrating event. It's the kind of thing that was outside the contemplation of the parties, but its actual effect on this particular contract, this tenancy agreement, isn't radically different to hasn't radically changed what the parties contemplated would be their obligations under the agreement over the 2-year period, because it's only for the isolation order is only for a 10-day period. So it wasn't a frustrating event. The contract wasn't frustrated, but the court did accept that an epidemic could be a frustrating event. So you'd have to think that it's possible for the current pandemic to amount to frustration. It just depends on what impact it's having on the contract. So if frustration does apply, what are its consequences? Well, the answer is that the contract is discharged from the moment in time of the frustrating event, and the parties are relieved of their obligations going forwards under the contract. Now, what the frustration doctrine doesn't do is it doesn't upset what's already happened under the contract before the frustrating event. So if you've already paid some money, or if you've already provided some goods or services under the contract before the frustrating event, and at the moment in time the frustrating event happens, you are in a loss situation, then according to the doctrine of frustration, those losses lie where they fall. You know, that's just tough. So there are, though, a couple of important exceptions to that. The first is that, independently of the doctrine of frustration, there's the ability to bring a restitution claim, a claim for unjust enrichment. So but this only applies if you've been, if you've received no value at all under the contract. In that case, then it could be said that you've suffered what's called a total failure of consideration. And in that situation, you can bring a restitution claim to make the other party give up what they've gained from the contract. But this only applies if there's been a total failure of consideration. So if the contract's been partially performed, you've got some of what you've paid for, you're not going to be able to bring a restitution claim. But the other main exception is that there's some legislation in England called the Law Reform Frustrated Contracts Act 1943, and that actually sets out a regime for unwinding frustrated contracts, and it only applies to some contracts, not all contracts, but the Act will apply to most commercial contracts, and it sets out a regime that sort of mitigates the otherwise harsh effects of this doctrine. So, for example, if you've already paid money under the contract and the contract becomes frustrated, you can have that money back. If you have a debt is accrued under the contract before the frustrating event, but you haven't paid it, then this Act says that you then don't have to pay that debt. There's also provision for dealing with expenses. So if you have if you have under the Act to return some money to the other side because of a frustrating event, then you're entitled to first deduct any expenses that you've incurred in relation to that contract before you give the money back. So if your contract falls within the scope of the Frustrated Contracts Law Reform Frustrated Contracts Act, then you may well be able to get something back for what you've spent on the contract before the frustrating event. So what if neither force majeure nor frustration apply? What else is there in the toolbox? Well, probably the next cab off the rank is termination. So one party may have the right to terminate the contract. Now, terminations are often considered quite attractive. Its big advantage is that it's a self-help remedy. So you don't need to go off to court to get an order that you're entitled to terminate a contract. You can just do it yourself, usually by serving some kind of notice under the contract. And you can also combine terminating a contract with a claim for damages. The big risk, though, with termination is that it could lead to litigation if you get it wrong. And really, what I'm going to explain in the next couple of slides is exactly what that risk is and how to manage it. So, turning then to termination and when it's available, there's basically two different routes to terminating a contract. You can terminate a contract using a contractual right to terminate, and broadly, you know, that will be under some clause of the contract, usually labeled termination or something like that, giving you the right to terminate in certain situations. Broadly, there's kind of two kinds of termination rights under a contract. Termination for convenience, which is all about being able to terminate just because you want to, and usually you'd be required to give some kind of notice period, or you might even be required to pay some compensation amount to the other side for terminating for convenience. The other kind of and obviously that could be highly relevant if you want to avoid carrying on performing a contract because of the effect of the pandemic. Then you know you should be checking whether or not you have a termination for convenience clause. The other kind of termination right that you might have under a contract is termination for cause. So this is all about like being able to terminate a contract if the other party has committed a particular kind of breach of contract that might be specified by the clause, or if there's been some change in status of the other party, for example, if they've become insolvent and entered into some kind of insolvency procedure. And again, that could be relevant in the current situation because a lot of businesses are suffering financial distress. So it may be that if your counterparty has had an administrator or appointed or something like that, that will give you the right to terminate the contract. The other route, though, to terminating a contract is pursuant to the common law, and this for what's called repudiatory breach. Now, this is an independent, freestanding right to terminate contracts. It doesn't depend on a contractual clause. You can terminate it for repudiatory breach even if you don't have a right to terminate under the contract. And the idea here is that judges will allow you to terminate a contract if the other side has committed a particularly serious breach of contract, one that goes to the very root of the contract, is the phrase that's most often used to describe what judges mean. Now, that's actually quite a vague concept and involves quite a lot of discretion with judges. So it can be hard to predict whether or not a judge will agree with you that the other side's breach of contract is serious enough to allow you to terminate for repudiatory breach. So you're running a risk that the judge might disagree with you unless it's a very clear repudiatory breach. The other way you can terminate for repudiatory breach is if the other side has renounced the agreement by either their words in terms of what they've said, or said in writing, or their actions. If they've made it clear that they intend to walk away from the contract and have no longer any intention to perform it, then they have renounced the contract, and that entitles you to terminate the contract. And just a short point here about the kinds of terminology used in contracts is quite important in this area. So certain words in contracts have special meanings. So if a term is described in a contract as a condition, what that actually means to lawyers and to judges is that the parties are taken to have pre-agreed that condition that term is sufficiently serious. A breach of it would be sufficiently serious to amount to a repudiatory breach. So if you breach a term that's labelled in the contract as a condition, then that will entitle the other side to terminate for a repudiatory breach. The other sort of key piece of terminology here is the phrase some of you might have seen in contracts, making time of the essence. So if a contract sets some kind of deadline for performing some obligation, and it says that time is of the essence, then what that means is that if the party doesn't perform in accordance with that deadline, then that is also taken to be a repudiatory breach. So what's the effect of termination? Well, it means that the contract is discharged from the moment in time of termination, and the parties are relieved of their obligations to carry on performing the contract from that point in time. But there are some exceptions to that you should be aware of. So it's not that first of all, it's not that the contract is as if it never existed. It still exists. It's just that it comes to an end early, and you don't have to carry on. Neither side has to carry on performing it from the moment of termination. In fact, though, there are still some exceptions to that. So if, for example, you breached the contract before the termination, and you've become liable to the other side for damages to compensate them for that breach of contract, the fact that the contract is then terminated doesn't get you off the hook. You're still liable to pay compensation for pre-termination breaches of contract. Also, if an obligation accrued before the contract was terminated, then that obligation survives. So, for example, if you were liable to, if a debt, a sum of money became payable under the contract on the 1st of March, and then the contract was terminated on the 15th of March, and at that time you still hadn't paid the amount of money that was due, then you're still liable to pay that debt now. And also there can be contractual exceptions to termination. So the parties can agree in the contract that certain clauses of the contract will survive termination. And there may be a list of clauses in the contract which survive. The kinds of clauses that you'd expect to survive might be things like the dispute resolution provision in the contract. So because that sets out what law applies to the contract and which forum the dispute should be determined in, including disputes potentially in relation to the termination of the contract or pre-termination breaches of contract. That clause carries on governing how disputes will be determined even after the contract has been terminated. And there could well be other provisions in the contract which are expressed to survive termination. And it could also be the case that a judge might decide that even though the parties didn't expressly say so in the contract, they must have intended certain clauses to survive. And so the judge could imply into the contract an agreement that certain clauses will survive termination. So what's the big risk with termination? Well, the problem is termination is attractive, but the problem is if you terminate a contract and it turns out that termination was unlawful because you didn't have the right to terminate the contract, then the other party will then become entitled to terminate the contract because of your renunciation of the contract. Your purported termination of the contract amounts to a renunciation of the contract because what you've said is you're not intending to carry on performing the contract. So if you didn't have the right to say that, then that's a renunciation and entitles the other side to terminate. And they can not only can they terminate the contract, they can sue you for damages, including what are called loss of bargain damages. Now, this idea of loss of bargain damages is only available if you terminate a contract under the common law for repudiatory breach. It's not available if you exercise a contractual right to terminate the contract. But if you are entitled to loss of bargain damages, what that means is you're entitled to damages to compensate you for the fact that the contract has come to an end early, much earlier than the contractual terms specified in the contract. So if this was a profitable contract for you and you were planning on making a profit on the remaining term of the contract, and that's taken away from you because you've had to terminate the contract because the other side have renounced it, then you're entitled to damages equal to those profits that you would have made under the contract. You can also recover things like amounts that you've had to pay to subcontractors in order to terminate those subcontracts because the head contract has ended. So you can recover any amounts that you've had to pay to subcontractors from the principal. So the point is that getting this wrong and terminating a contract unlawfully, where you don't have a right to do it, it turns out you weren't entitled to it, can be very expensive, and so it does pay to get advice before you go ahead and terminate a contract, not afterwards. So apart from termination, is there anything else left in the toolbox? Well, you can always sue the other side for damages. That's all about getting compensation for loss that you've suffered as a result of a breach of a contract. So if the other side not performing the contract amounts to a breach and that causes you loss, then you can sue for damages. Of course, that involves going through a court proceeding and all the time and money of that. And it's only going to be any good to you if you're the one who's ready to perform the contract and it's the other side that's not performing. You can also try to seek an order from the court for specific performance of the contract. So this is all about getting an order from the court requiring the other side to perform the contract in accordance with what the contract says should happen. So actually making them, you know, deliver the goods or the services that are required by the contract. This is only available in very limited circumstances, because the main kind of idea of our legal system is that the primary remedy for a breach of contract is damages, compensation for loss, and the court won't ordinarily require somebody to perform a contract. Instead, they will make them pay damages. So the first problem that you'd have to overcome in getting an order for specific performance would be, well, you know, you need to be able to show that the damages would not be an adequate remedy, and you may well not be able to get over that hurdle. And even if you can, there are other hurdles you have to get over as well. So could be pretty difficult to get an order for specific performance. And finally, of course, you can try to reach a commercial agreement with the other side. And of course, the advantage of that is you can agree anything you like with the other side. You're not limited to the kinds of remedies that a judge can give. You can agree anything you want. On then to my sort of checklist of what you should be doing and what you shouldn't be doing to manage disputes in the current environment. Now, you know, I sort of appreciate that litigation might not be the #1 priority for a lot of businesses at the moment. There's a lot of other urgent issues on their minds, but there probably are still some things that, or at least that we think you should be doing now in order to avoid storing up trouble for yourself in the future. So the first there is you should think about what witnesses you might need for any dispute, and factoring that into your thinking about redundancies, if your organization has any planned redundancies. Because, you know, I'm a litigation lawyer, and I start by thinking about the trial and working back from there. And one thing that I know is that if you don't have a witness, then you don't have a case. So you should think about if you are going to need witnesses for a potential dispute, then you should think about that before making them redundant. You should be proactive about reaching out to the other side and trying to agree a commercial resolution with them if you can. If you can agree something, then that is likely to be a better outcome than you're going to be able to achieve through litigation. But the third point there is that if you are going to talk to the other side, you should think about doing it on a without prejudice basis, so that if you do end up in litigation in the future, nothing that you say that is if you've said something that could be adverse to your case, it won't get back to the court if you've specified that what you're saying is without prejudice. You should think about notifying any losses that you might have to your insurers. You might want to discuss this in the first instance with your insurance broker. There's a range of different commercial insurance policies that could be relevant to the kinds of losses that businesses are suffering at the moment. You should, as I've already said, check your contracts to determine whether or not they contain force majeure clauses, and get advice about force majeure and or frustration if you need to. What else should you be doing? Check whether or not there are any clauses that might mean that you need to serve any notices under your contract. For example, a force majeure clause that provides for termination of the contract might well require you to serve some kind of notice within some kind of time limit if you want to rely on that clause. So you should check that and that. You should also think about if you think you have any claims under any of your contracts, you should check whether or not the contract sets any time limit for bringing those claims. And you should also check what the statutory limitation period is for bringing those claims, and make sure that everybody in your organisation who needs to know about that is aware of those time limits. Should take steps to mitigate your losses. If you don't take reasonable steps, then you're probably not going to be able to recover from anybody else losses that could have been avoided through reasonable mitigation measures. You should consider writing a letter to the other side, reserving your rights. That can be useful because it makes it far less likely that you'll be taken to have waived your rights by anything that you do subsequently if you've written a letter reserving your rights. You should issue a document hold notice to make sure that any documents that are relevant to the dispute are preserved. If you don't, that could be held against you in a dispute. You could even lose your claim because you haven't made enough of an effort to preserve relevant documents. And you should also think about making sure that people in the business know about how to know to avoid sending off emails or WhatsApp messages and things that say critical things about your organization or things that could be adverse to your case, because those could well have to be disclosed to the other side. People may not be aware of that unless you take steps to structure communications so that you maximize your chances of being able to claim legal privilege over them. And finally, what shouldn't you be doing? Don't terminate contracts without taking advice first, as I've explained. Pretty much every, I've been involved in quite a few termination cases in my days, and they pretty much all start in exactly the same way, which is one party assuming that they're entitled to terminate a contract without taking advice first, and thinking they'll only take advice if the other side kicks up a fuss, and by then it's too late. You need to take advice about termination before you do it, not afterwards. Don't assume you can ignore a contract merely because it contains a force majeure clause. You've got to think through those different things that I outlined earlier, and don't allow documents that could be relevant to be destroyed. And finally, don't assume that you have to make a choice between trying to agree a commercial resolution with the other side and trying to agree something amicably with them on the one hand, and taking steps to protect and enforce your legal rights on the other. It's not a choice between those two things. You can do both. And in my experience, pursuing both approaches in parallel is often the most successful way to go about things. If you're finding it difficult to resolve a dispute, then showing that you're demonstrating that you're prepared to follow through with litigation if necessary often makes it more likely, not less likely, that you'll be able to come to some kind of commercial resolution with the other side. So, sorry, I'm conscious that's taking just a little bit longer than planned. So I'm just going to try and see now if I can bring up your questions, which I'm not immediately, I'm afraid, seeing. Here we go. Yes. Okay, so first question here, Caroline has asked, will a force majeure clause override the ability to rely on frustration? Yeah, and in a sense it probably will. If the force majeure clause is broad enough to include the pandemic within its scope, then that makes it much less likely that frustration will apply, because frustration is all about the court interfering where something that's happened that was outside the contemplation of the parties at the time they made the contract. Now, if they've agreed a force majeure clause that's broad enough to include pandemics, then clearly they have considered pandemics at the time they entered into the contract, and they've made their risk allocation in relation to pandemics in that clause, and so that leaves very little scope for frustration to apply. So you're stuck with whatever. Most likely you're going to be stuck with whatever that force majeure clause says about what should happen. Another attendee asks, does the 43 Act apply to tenancy agreements that may have been frustrated? I have to confess I would have to check that. I'm afraid I don't know. We'll get in touch with you to give you the answer. It applies to most commercial contracts. I don't think it applies to insurance contracts, but I'm not sure if it applies to tenancy agreements. Another person asks, if a force majeure clause is silent on payment and there's been a prepayment, can the payee refuse to refund? Now, this is an interesting question that a lot of people have been asking us recently, because it's a bit of a lacuna really in the way these force majeure clauses are drafted, because they really only deal with what should happen going forwards in terms of the parties' obligations going forwards after the force majeure event. So they usually, and as I said, they usually just say the parties' obligations are suspended or the contract's terminated. What they don't tell you is what should happen to things. What should be the answer to things that have already taken place under the contract. So here you're asking if there's been a prepayment, can the payee refuse to refund? Well, on its face, yes, because the force majeure clause doesn't require the refund. It doesn't say anything about the refund. So, I think some people have suggested that maybe the courts would in these kinds of situations apply the same kinds of principles that are in the Law Reform Frustrated Contracts Act, and use those principles to decide whether or not, which would point towards requiring the payee to refund. But just as I was saying in relation to the previous answer, it's frustration isn't meant to apply where the issue's been dealt with in a force majeure clause. So arguably the principles in the frustrated Law Reform Frustrated Contracts Act don't really have any application to force majeure situations. So you could fall back on a restitution claim. So the payee might have to refund if the other party has received absolutely nothing for what they've prepaid. Then there could well have been a total failure of consideration, and which gives rise to a restitution claim. So it's not really anything to do with the force majeure clause, but there might be a separate claim in restitution to get that money back, that refund. And so I wouldn't, if I was a payee, you wouldn't assume that you can refuse to refund. The situation really needs to be analysed, and including looking at whether or not there might be a restitution claim if they don't refund. Bethany asks, as a local authority, we're likely to be on the other side of any requests to terminate. Have you got any advice on dealing with suppliers who may wish to terminate when we intend to keep the contracts running? Yeah, I think it's really, I suppose it's just really about analysing whether or not they have a right to terminate or not. And if they don't have a right to terminate, then you're within your rights, to insist that the contract carries on being performed. And as I said, it may well be that there's some kind of commercial deal to be done in these kinds of situations, and you're probably best off exploring that with these people who are requesting termination, seeing if you can come to some kind of accommodation with them that works for everybody. But perhaps you should consider doing that, having those discussions on a without prejudice basis, so that if things do head in a litigious direction, then anything you've said won't be held against you. So I think that's probably all the advice I can give with that much information. Somebody else, Aid, has asked, can reliance on force majeure allow for parties to indefinitely suspend the performance of a contract? Yes, there's really two different kinds of force majeure clauses, or two main kinds. One suspends the performance obligations only for the period that the force majeure event, in this case the pandemic, is impacting and causing the inability of the party to perform the contract. And in that case, then the suspension won't be indefinite. It will only last as long as the force majeure event and the impact of it is interfering to the required degree with the ability of the party to perform the contract. But there is another type of force majeure clause, which is all about terminating the contract altogether. And if it's that kind of clause, then the party's obligations are not just suspended; they are at an end entirely. And in that case, so in that sense, the suspension would be indefinite because there's been a termination. You need to read the clause to know whether or not you're dealing with a suspension clause or a termination clause. Sarah asks, if a party decides to terminate when they don't have a right to do so, could this amount to willful breach? Could repudiation be subject to limitation of liability caps? What could amount to acceptance of wrongful termination? Okay, so taking those in turn, could a termination where somebody doesn't have the right to, could that amount to a willful breach? It could, but it probably depends whether or not the person knew that they didn't have the right to terminate, or whether they're just mistaken in their view that they were entitled to terminate. And that's going to be quite a difficult thing to prove, because it involves trying to prove what somebody knew at the time that they were purporting to terminate the contract. But it could be willful if you can prove it. Could repudiation be subject to limitation of liability caps? That is an interesting question. It probably depends to some extent on the drafting of the limitation of liability cap and what liability it says it's limiting, and particularly, is it limiting liability for termination? And if is it only limiting liability where there's been a termination pursuant to some contractual right to terminate under the contract, or is it also attempting to limit liability for repudiatory breach and giving rise to a right for the other party to terminate under the common law? Because if it's not clear that the limitation of liability extends to that second kind of termination, then it might not be effective to limit that liability, I would say. You could get into some quite interesting questions about whether or not it's possible for a party who has repudiated the contract to successfully limit their liability for that repudiation in the contract. And I think that's an issue that we would have to look into. I'm afraid I don't know whether there has been case law on that or not. I suspect there may have been, and I'd like to take a look at it before I get back to you. And the last question is from Tamsin. Can Party A argue that the government advice of 23 March, which has prevented Party A from being able to perform, amounts to a cancellation of the contract by Party B as of the date of the government advice, paving the way for Party A to rely on certain sections of their terms and conditions, which would allow them to withhold part of the deposit paid by Party B? There's no force majeure clause in the terms and conditions. Okay, I don't think you could say that the government advice of 23 March entitles you to say that the other side has cancelled the contract. What it sounds like you might be able to argue is that the contract has been frustrated as a result of that government advice, it could well be a frustration case that you're describing there, and but if it is a frustration case, you probably aren't going to be able to rely on the terms and conditions in your standard terms to allow you to withhold part of the deposit paid, because the terms and conditions aren't going to be of effect going forwards anymore, and because the effect of the frustrating event would be to discharge the contract from the moment of the frustrating event. You may not be able to withhold their deposit that's been paid if this is the kind of contract that the Law Reform Frustrated Contracts Act applies to, because if it's within the scope of that act, then that act sets out certain rules about what should happen to money that's already been paid under the contract before the frustrating event. And basically the rule is that money that's been paid has to be returned, except that you can deduct from that money that you have to pay back your expenses that you have incurred performing the contract to date. So it could be a frustration case, but if it is a frustration case, you're probably not going to be able to rely on that clause, and instead you're going to, assuming the act applies and your contract's within the scope, you're probably going to have to give the money back. Okay, I think that's all we've got time for today.